Thank you for listening to this PYA webinar recast. PYA is pleased to offer this alternative way to access our thought leadership. This is a recording of a previously delivered webinar. The information is accurate as of the date of the original event. The video recording, slides, and associated material for this and all PYA webinars are available on our website at pyapc.com. This podcast is for educational purposes only. It is not intended to be used as legal advice or an official opinion.
Hello, and welcome to the 7th annual Let's Talk Compliance Conference, co-hosted by Foley & Lardner and PYA. I'm Jana Kolarek, a partner in Foley's Healthcare Practice Group, and this is my co-host, Angie Caldwell, Consulting Principal at PYA.
We want to welcome all of our attendees and our speakers today. And I want to play historian for just a moment about the Let's Talk Compliance series. This is our 7th annual virtual conference, and it's because of our partnership with Foley & Lardner to put this on every year with great content and fantastic presenters, as well as all of our attendees that make this a success every single year. So we thank everyone. Thank you, Foley & Lardner, for your partnership, and thank you so much to my co-host, Jana Kolarek, for 7 years.
Likewise, Angie, thank you so much. It's been a great 7 years. And thanks again to all the attendees for making this what it is. We have increased numbers every year, started as a small in-person event in Florida and have expanded nationally. So thanks to the partner PYA, thanks to the attendees, and thanks to the great content that we have because of the great presenters that we have. So thanks. It's a great thing to be at 7 years.
Absolutely. Let's talk about some housekeeping items. Let's get in here. So slides are available under the resources panel for our attendees. So what is our resources panel? It's the one that looks like a little cloud. So all of the squares on your screen, attendees, those are resizable. Get comfortable, move them around, make them bigger, make them smaller. But please know that they can be customized for your viewing pleasure throughout the presentation today. Also, you may enter questions in the Q&A panel. The Q&A panel is the one that has the little question mark on it. Feel free to engage in that Q&A panel. To the extent our presenters have time to answer some questions, they may be able to do that. If not, we take a note of those questions and follow up as we can after the presentation. So if you run into any technical difficulties at all, please know your first course of action is to refresh your browser. We're also offering CPE and CHC credit as part of this event. So for CPE credit, you must be logged in the entire duration of the session, and you must answer all 3 polling questions that are dispersed throughout the presentation today. Once you have successfully completed these requirements, you'll see a CPE certificate available for download in the continuing education window. You'll also be receiving an email with that CPE certificate. For CHC credit, we are in the process of getting that approval, so it takes about 6 to 8 weeks following the event to process that for that credit. Please be sure to complete the CEU survey found on the webinar dashboard so that we can determine the type of credit that you are seeking. Jana, tell the audience a little bit about the CLE credit.
Sure. So for us lawyers, Foley & Lardner is offering the CLE credit. To be awarded the CLE credit, you have to be logged in for the session, the entire session, and you have to record the 5-digit CLE code that will be announced later on the attorney affirmation form that's in the resources panel. So CLE guidelines, and this is kind of just an important note, prevent us from verbally announcing the code. So you'll need to wait until the end of the program for the CLE slide. You must be in front of the monitor for the full duration of the webinar to view the code at the end. You must sign and return the form after the session to LSHC events at lshcevents@foley.com. CLE credits will take about 6 to 8 weeks to process. So please expect a little bit of a lag. It's not going to be that day or the next week. Our first session today we'll get to the exciting stuff, is going to be led by PYA's Marty Ross and Foley and Lardner's Matt Krieger, covering a new era for interacting with federal agencies. And now we'll turn it over to our presenters. Take it away.
Thanks so much, Jana, and thank you also, Angie. It's a pleasure to be here. We appreciate everybody coming in. So just to give a bit of background on myself, and then I'll let Marty give some background on herself. I've been at Foley for about 4 years. I came to Foley after serving as the United States Attorney in the Eastern District of Wisconsin. Before I was serving as U.S. Attorney, I was one of the assistant U.S. attorneys, one of the federal prosecutors in that office, doing first civil False Claims Act enforcement, usually involving healthcare entities. And then I moved to the criminal side and was doing criminal enforcement. I was the healthcare fraud coordinator for criminal healthcare fraud enforcement matters. Now in private practice, I work with companies helping respond to government investigations, helping do internal investigations, a lot of False Claims Act litigation, as well as other white-collar matters. I also help advise on compliance matters with policies and programs so that companies can avoid ever having to be subject to government scrutiny. I'm excited to talk with you here, but before we get into the subject matter more, I'll let Marty introduce herself.
The firm 12 years.
Excuse me, Marty, I'm really
muted.
I'm so sorry to interrupt you. Yeah, I didn't hear you at the start there.
There we go. Yeah, it helps when you hit the unmute button. That is a good key to doing effective webinars. So I'm Marty Ross with PYA in the firm's Kansas City office. I've been with the firm 12 years. Working in primarily regulatory compliance. I'm a recovering attorney. I did 2 decades in the trenches on regulatory and transactional matters, but hung up the attorney-client fairy dust and now work with providers through different complex regulatory schemes.
Terrific. So you've got 2 lawyers talking with you here. And someday I hope to be like Marty and be recovering. For now, I'm still in the trenches. So here's what we want to talk with you about today. Are 2 overarching changes from the last year that we think have created a new era of interacting with federal agencies. The first of these changes is the overturning of Chevron, that we now live in the post-Chevron world. And so we'll talk about what that means and what the regulatory challenges after Chevron have looked like. The second major change in recent history here is the Trump administration being elected and now taking office this week. Obviously, some of these changes with the Trump administration coming online are very recent, and it's resulting in many headlines and executive orders coming out this week. And I want to just acknowledge that people have very different feelings about all of those changes. For today's webinar, we're not planning to try to address all of those very current events in the headlines today, but instead want to give a longer-term perspective about what to expect with the Trump administration's approach to rulemaking overall, its approach to administrative enforcement, as well as False Claims Act enforcement. And so, again, if you've got a question about a particular EO that came out this week, this probably isn't the right setting to do it in this webinar. Happy to take those questions with folks offline. Marty will be addressing a couple of the EOs that affect particular things. But again, we want to try to offer you a longer term perspective to think for your organization of how to interact with federal agencies. And even if it's not a direct interaction, how to think about in terms of risk and compliance, the regulations, the agency guidance that you're dealing with every day. So that's where we're going to end the discussion. Throughout this, we'll be talking about takeaways for your organization, but we also will try to leave some time at the end for that very practical discussion. We do welcome your questions along the way here through the chat box, and we look forward to talking here. So let's keep moving forward here. So first of these 2 overall changes are our post-Chevron world, and that gets us to our first polling question.
Our first polling question is, which of the following best describes your familiarity with Chevron and Loper Bright? Never heard of them? Some familiarity, but don't know why they matter, or very familiar? We're going to give you a few moments to answer the poll. Please remember that for CPE credit, you must stay logged in the entire duration of the presentation and must answer all 3 polling questions. For CHC and CLE credit, please know you don't have to answer the polling questions to receive credit, but we would love to hear from you and would love your participation as part of the polls. So we're going to give this just a few more minutes for more participants to answer the question. But Marty and Matt, if you want to begin commenting as the answers come in.
Sure. So already from the answers, it looks like we have a bit of a bell curve with, call it maybe 15-20% of folks not having heard of these cases, maybe 30% being very familiar, and then the majority of folks kind of in between. So that's helpful feedback for us, and we'll try to tailor comments accordingly, but certainly don't want to turn this into an administrative law class. It was my favorite class in law school, but we'll Marty just gave me the look. It was a fun class, and so that's something that I'm happy to talk about more offline too, of why administrative law is the greatest class that's ever been created for law schools.
Thanks for answering the poll.
All right. So moving on. So particularly for those who may not be familiar at all with Chevron deference, the quick overview of it is Chevron was a Supreme Court case that addressed the question of when an agency has a regulation of how, and it's in question of how courts should deal with it. So taking a step back, agencies are creatures of statute. You don't find in our Constitution anywhere a reference to the Department of Health and Human Services. Instead, Congress passed laws that said what the Department of Health and Human Services is and what authorities it has. The subcomponent of HHS, CMS that you deal with all the time, it gets its authority from the Social Security Act, from a statute that Congress passed. And so what can often happen then is by the powers given to CMS and the Social Security Act, it puts out regulations, and those regulations have to have their authority based on what the statute was. And there can be challenges. Sometimes a regulated party thinks that the regulation isn't a fair rule to put out under the statute that governs CMS's authority. The Chevron case said that when you have ambiguity, if the statute doesn't clearly answer whether CMS can put out the regulation it has, if there are multiple interpretations of the statute, that the court would defer to CMS, so long as its interpretation was permissible, as long as it was reasonable. The rationale was that if Congress had ambiguities in its statute, that it probably meant to delegate authority to CMS to decide what the statute meant and to fill in gaps. And so when Chevron was first issued, it didn't seem to, the court itself and Justice Stevens has said he didn't view it as this big change in the law, but it was taken that way. And so since 1984, many decisions by lower courts have cited Chevron to say that it will defer to the agency's regulation, its interpretation of what it's permitted to do under the statute. Chevron meant that the agency almost always won when there was a question, over 90% of the time when Chevron was invoked. So moving forward, before we get to what happened to Chevron, there are related deference doctrines that I would say provided even more authority to CMS and to agencies. And so Chevron, again, is particularly about a regulation that CMS puts out. But then, as you all know, CMS and other agencies put out lots of sub-regulatory guidance, things like state operations manuals, policy guidance, FAQs. And those often will fill in the gaps even more than the regulation, and in a way are the agency's interpretation of their own regulations. And so when those are challenged, there are questions of how courts should view that. And the Kaiser case we mention here gives a rule of deference even to those interpretations. When there are other agency actions that are not regulations, such as these FAQs, et cetera, that aren't interpreting a regulation particularly, then a lower level of deference was in place. But all of that changed last year with the Loper Bright decision, when the Supreme Court said very clearly that Chevron was overruled and that courts, not agencies, have the final authority to interpret statutes. That courts actually are not permitted to defer to an agency's interpretation when the statute is ambiguous. That the court should instead apply its independent judgment, all the tools of statutory interpretation that courts are used to doing, to decide what a statute means. It did say that the regulations previously upheld under Chevron deference would remain in effect. And so the court tried to indicate that it wasn't immediately invalidating a lot of different statutes. However, I think lots of questions about whether they are drawn into question, and particularly because another case of the same term last year that we reference here at the bottom corner post interpreted the statute of limitations that applies to challenges to the regulations under the APA to run not from when a regulation was issued, but from when a party suffered injury. And so it potentially lengthens the time that regulations on the book can be challenged. So just pausing here for a second, the big picture takeaway is that whereas in the past we've lived for 40 some years under a regime in which agencies had a lot of authority to fill in gaps, construe ambiguities in statutes, and courts were going to defer, which one could argue emboldened agencies to be perhaps more ambitious in regulations that they put out, and that made regulated parties perhaps less willing or interested in trying to challenge those regulations. But under the new scheme, that's not the case anymore. So that has already led to, and we're going to flesh out this more, has already led to more challenges to regulations, and I see no reason to think that that won't continue to happen. With the challenges to regulations that are happening, there are a lot of interesting questions about where these suits are filed. The federal courts are divided into these different circuits that are shown on this map here, and different judges in different areas have different dispositions towards regulatory challenges. Many of the most successful challenges are being filed down here in the Fifth Circuit, which covers Texas, Louisiana, Mississippi. And so you'll hear a lot of discussion about challenges being filed in Texas, where the Fifth Circuit has been particularly active in sustaining challenges to regulations. When these suits are filed under the APA, they're often paired with a motion for preliminary injunctive relief, meaning even before the court gets all the way through a case to immediately ask for the regulation to be stayed or put on pause while the litigation continues. For the sake of time, I won't go into all the details of what it takes to get a preliminary injunction, but it is sort of the playbook that is playing out right now. And because, as we saw, there are different courts in different places, these suits can be filed in different places, and you have the potential for conflicting decisions. Marty's going to give us an example of those, of one of those in a moment. And for those of you who are familiar with the Corporate Transparency Act, which requires disclosure of beneficial owners of companies, that's been a situation where whether that regulation is stayed or not has ping-ponged between courts to the point where yesterday the Supreme Court itself weighed in and actually has said that the Corporate Transparency Act can go forward. That's just one example of how these challenges to regulations create a level of uncertainty about when and whether they will be in effect. So with that, I'm going to let Marty take us forward.
Well, with Loper Bright having been decided at the end of June, we very quickly back by July 3rd, saw the potential for mischief under this new regime. And we'll take a deeper dive into an example with Section 1557. 1557 refers to a provision within the Affordable Care Act that made prohibition on discrimination based on different classes apply within healthcare programs as well as to healthcare providers. And that statute passed, as you remember, in 2010. We saw the first regulations implementing 1557 during the Obama administration. The Trump administration came into power then in 2017, rewrote those regulations. The Biden administration shows up in 2021, and then in 2024 issues, once again, revised regulations implementing 1557. To say that this has been controversial then would be an understatement. Key provisions of 1557 and why it has attracted such attention include discrimination on the basis of sex. And in the Biden 2024 regulation, sex was defined broadly in the regulation, and specifically to include gender identity, which was a lightning rod of criticism for this regulation as it went final in the spring of this year. That resulted very quickly in litigation. And those litigations, just because of the timing of when the regulation was released, when the lawsuits were filed, and when the effective date of the new regulation was set, again, coincided very closely with the Loper Bright decision. So we're going to start with a lawsuit in Mississippi, which involved 15 states' attorney general challenging the gender identity provision of the new 1557 regulation. The court there issued a nationwide preliminary injunction prohibiting on those enforcement of those provisions that would prohibit discrimination based on gender identity. The reason we had a July 3rd decision is because the compliance date for this new regulation was set at July 5, and we knew that the courts, of course, were closed on July 4, so July 3 is when we got all the activity. This is a very precise decision issued by the court in Mississippi, citing the specific provisions of the new regulation which were enjoined from enforcement. Same day, in Florida, a different case that had been a Florida-only plaintiff, the court there issued a preliminary injunction effectively consistent with the court in Mississippi, but citing different provisions in the statute, the regulatory language. A little further then to the west in Texas, and it's, as Matt noted, lots and lots of this litigation occurs in Texas. But in Texas v. Becerra, which involved two states' attorney general, Texas and Montana, the court went much further. And not only did it enjoin the gender identity provision in the definition of sex discrimination, it took out the entire regulation, all of the provisions with regard to both the specific prohibitions on discrimination, as well as the administrative provisions that were intended to bring organizations into compliance with those anti-discrimination provisions. So the entire statute, my mistake, the entire regulation as promulgated by the Biden administration was no longer effective in Montana or in Texas. So where things then stand, we find on the Office of Civil Rights website, HHS-OCR is responsible for enforcing the 1557 regulations. You have then now this recitation of how the rule applies in different states based on the impact of these court decisions. And so this, of course, raises the question going forward, given the map that Matt showed you, are we going to have different regulations in different jurisdictions as we expect to see an uptick in this type of litigation challenging regulatory opinions? Another case that went similar to Loper Bright concerned the Federal Trade Commission's ban on non-competes. And there were two actions that were moving forward, one in Pennsylvania, one in, you guessed it, Texas. The court in Pennsylvania actually upheld the FTC's authority to issue the non-compete rule. the court in Texas said that the FTC did not have authority. So who wins in that case? FTC took the opinion that the Texas court's decision was binding, and thus it chose not to move forward with the non-compete prohibition. But again, it sort of creates this picture. If you can have several courts uphold a regulation, but then one court say, no, it is not the best interpretation of the statutory language, does that then mean that that regulation is going to be ineffective across the nation? It's something certainly that we're going to need to monitor going forward as we see regulations come online. Of course, Matt made reference to the flurry of executive orders at the beginning of this week, and one specifically is going to have some impact on this ongoing 1557. And that's the order, the executive order entitled Defending Women from Gender Ideology, Extremism, and Restoring Biological Truths to the Federal Government. And as part of that executive order, in Section 3, the President ordered the Secretary of HHS to provide to the U.S. government external partners clear public guidance, and then specifically directing agencies to remove all statements, policies, and regulations that refer to gender ideology. So, of course, we have this provision now in 1557, the regulation. Of course, an executive order cannot overrule a regulation that's subject to notice and comment, but we would take this as a directive to HHS to certainly publish yet another 1557 regulation that would not include that broad definition of sex discrimination. So certainly something to watch moving forward. And specifically areas that we're likely to see some challenge, I'm going to defer to Matt on the first of these lawsuits. He's more directly involved.
Sure. We are just picked a sample of additional suits that are going forward. This first one here is a suit that I'm counsel of record. We filed this suit last week on behalf of the Texas Association of Home Care and Hospice, challenging CMS's Hospice Special Focus Program. I won't go into tons of weeds on it, but it's an example of the types of challenges that will come forth. Congress passed a statute that asked CMS to create a special focus program, meaning a program that would provide a higher level of surveys and scrutiny of certain hospice providers that would be deemed to be more likely to be out of compliance with Medicare requirements. That was the statutory language. It was related to compliance with Medicare requirements. CMS then put together a program where it selected hospices to put into this special focus based not only on, say, survey findings of deficiencies or lack of compliance, but also on other factors such as consumer surveys. And so the lawsuit challenges CMS's authority to do the special focus program, saying that they exceeded their authority given under the statute. And we cite Loper Bright to say that the court doesn't need to defer to the agency's view of the statute in this. So again, another example, and I'll let Marty address the others.
Certainly the litigation around the HIPAA privacy rule to support reproductive health care privacy, which now requires that attestation from one requesting release of PHI that includes reproductive health care. There was a challenge filed by the Attorney General of Texas in September, challenging HHS OCR's authority to promulgate that regulation. At that point, there was no preliminary injunction sought. However, in a parallel case that was actually brought by a doctor challenging HHS authority, the court did issue a preliminary injunction on December 22nd, the day before the compliance date for the new HIPAA rule. However, the preliminary injunction issued in that case was only specific to the plaintiff. The court did not attempt to issue some type of nationwide injunction in that private litigation. So something definitely still worth watching. At this point, those rules remain in effect. The compliance date has passed as of December 23rd. Again, we expect to see more developments on this particular area. You're probably most familiar with the American Home Care Association's challenge to the nursing facility minimum staffing rules that the Biden administration promulgated last year. That lawsuit was filed soon after that regulation was published in May. Because of the delayed compliance dates of those different provisions, we haven't seen a preliminary injunction yet in this, but anticipate this will be ongoing litigation, or, as we'll talk about in just a minute, likely a regulation to be withdrawn by the Trump administration. And finally, of course, we'd be remiss not to mention the Texas Medical Association's ongoing litigation around the No Surprises Act, that they continually have challenges to the structure of the program, the administration of the program. And I think they have new fuel to their fire now with Loper Bright saying that the CMS overstepped in the manner it has enforced the No Surprises Act or regulation. For other topics we are likely to see litigation, though we have not seen formal lawsuits filed to this point, are a whole range of healthcare regulations. We have already some restrictions on site-neutral payment, well, some site-neutral payment requirements, likely to see more going forward. Interesting to see how hospitals will challenge those regulations. Medicare Advantage plans and different regulations that have been imposed on them over the last 3 years, everything from star ratings to risk adjustments to how audits are conducted. Will we see challenges, more challenges coming out of the plans, similar to the litigation over the specific calculation of star ratings that we've seen this year, or last year. State challenges to different Medicaid rules are probably ready to be teed up in the way CMS has crafted those particular regulations. At-home care reimbursement wages, 340B, different ways that the ACA has been implemented, everything from short-term limited duration plans to fixed indemnity insurance plans, the different prohibitions on those types of product, whether we'll see challenges coming from the marketplace, again, with the now broader Loper Bright authority of the courts to interpret the regulations with their toolkit. I wonder if they hand that toolkit out when you're confirmed. I was just curious about that piece. But and finally, I think, and we'll go deeper into this, the OIG's enforcement authority and different tools that OIG has used with providers, particularly the statistical sampling methodology of saying, we're going to look at this many claims and then determine that's a statistically valid sample, and then make a demand over the entirety of claims that have been submitted by that provider over time. Similarly, the corporate integrity agreement and the onus that places on providers that settle lawsuits with the government, and whether CMS in fact has the authority to make the types of demands and requirements that you see in CIAs. So that's Loper Bright. Let's take this to the next step and talk about the change in administration and the likely impact that's going to have on agency regulated interactions. And start with the basics. We have a whole set of regulations that were promulgated by the Biden administration. What happens now with the change of administration this week? And that starts, of course, with yet another executive order, the regulatory freeze pending review. The language of this EO is nearly identical to the EO that was issued by the Biden administration in January of 2021 and the Trump administration in 2017 and the Obama administration in 2009. It's a very routine change of administration that we will freeze the ongoing regulatory process to evaluate what, if any, action should be taken with regard to the prior administration's regulations. Now, you've probably been reading a lot of sensational headlines around this regulatory freeze and how it's tied to the hands of agencies. In fact, it's relatively mild in its actual impact. First, under the EO, an agency cannot propose or issue a rule until a designated department or agency head approves that rule. So we have now a set process for rule approval before it is released over to OFR, Office of Federal Register, for publication. There are generally other processes that are in place depending on the type of rule involved, but now we're just centralizing that to the agency head or designee for this period while we're within this regulatory review. There is a provision specific in the EO that says the Office of Management and Budget Director can override these freeze requirements under urgent circumstances, such as emergencies, such as regulations that are required to be published either by statute or by a court order. They can be exempted out from that freeze. Additionally, the EO requires that any rules that were sent to the Office of Federal Register that have not yet been published in the Federal Register, their directive to OFR not to move forward with their publication. And finally, a postponement for 60 days of the effective date of rules that have been published in Federal Register. And again, this is narrow. This is that limited range of rules that have been published in the Federal Register, but they have not yet reached their effective date. So very common that we'll see, for example, take the annual rulemaking we do in the Medicare program, the OPPS rule. When you read that in November, when it was published final, you would noted that it said this rule is effective January 1st, 2025. And in fact, this EO would have no impact on that rule because in fact, it was already past its effective date. You also have rules that are past their effective date, but are not yet reached their implementation date or their compliance date. An example here, as part of the OPPS rule, we had the new Medicare conditions of participation on maternal health. Their compliance dates are pushed at least until July 1st of 2025. But because we're past the effective date, the EO does not impact that. So if you thought you had a breathing room on those new conditions of participation, in fact, as things stand today, the compliance date still sits on July 1st for the first round of those new COP requirements. The second piece of the puzzle is the Congressional Review Act, which, as a matter of course, anytime an agency publishes a regulation, Congress has the authority within 60 days to pass a resolution that overturns or rescinds that regulation. When you have a change of administration, the CRA expands out that authority. And rather than it just being the opportunity to object from the date of publication 60 days, it actually has a look back period. So the new Congress can look back and bring such a rescission resolution to regulations that became effective during the prior administration. There's a time limit that is based on when Congress was last in session. And in fact, I think the date, I've read August 1st, I've read August 24th. I'm not exactly sure which it is, but that will be the reach back date. This is just now starting because of that timing requirement within the CRA. It was yesterday that senators could first propose one of these rescission resolutions. It won't be till February 5th that representatives can move forward with those resolutions. There are roughly about 100 of these regulations out there that became final between August 1st and the inauguration. It'll be interesting to see what, if any, will be challenged. One particularly impactful to the healthcare world would be the Consumer Financial Protection Bureau's medical debt rule that was released in early January. This is the rule that prohibits consideration of an individual's medical debt in their credit rating. And it'll be interesting. There have been folks in the Trump administration who have objected to this rule. It'll be interesting to see if we see the CRA used as a vehicle to strike down that regulation going forward. So stay tuned on that one. Anything else? The stuff that has already been past its effective date, and say anything before August 1st. And in fact, the Biden administration was very purposeful in getting a lot of regs out before that date. Many came out in May, if you recall. All of those now, to overturn them, you have to go through the notice and comment rulemaking process. And likely targets that we expect to see very soon out of HHS would be nursing home staffing levels, the previously referenced HIPAA reproductive rights, as well as section 1554. But again, it is obviously a deal to go through notice and comment rulemaking. There's time developing the proposed rule. There's the time reading the comments. There's the time getting to the final rule. So yes, we likely will see some regulations overturned this way. We saw some of that in the first Trump administration coming out of the Obama administration. But don't expect this to necessarily be an overhaul of every regulation that you don't like. This is much more of a surgical tool for correcting what they believe to be prior administration's mistakes in promulgating certain rules. So yes, the remedy of the courtroom primarily remains the vehicle by which those who are regulated that do not like the regulation will move forward with challenges. Finally, we also have other tools available to the Trump administration moving forward, how they choose to exercise enforcement discretion, telegraphing to the industry that it does not intend to bring enforcement actions under certain types of regulations. And then last but not least, there are the proposed rules. The stuff that wasn't finalized prior to the inauguration. The ones of interest here that we'll be watching closely are the proposed changes to the HIPAA security rule, published in November. Comments will be due March 7th on that. We also have the Medicare Advantage Part D proposed rule that has comments due January 7th, the advance notice with comments due February 10. We'll be watching closely to see if any of these are withdrawn or if the comment period is extended out for those. But they are still live proposed rules at this point, and those comment periods remain in effect. So if you, like many, are considering commenting on the security rule, that deadline still is at March 7th until further notice. Matt, over to you on these options for the Biden administration.
Sure. And, yeah, I think if it's all right with you, I'm going to move to we're going to move to here. So I think to kind of frame where we are, what I think Marty has just demonstrated is that after Loper Bright, if you've got problems with the regulation, the courtroom is now much more of a remedy than it was before. And that the change of administrations to the Trump administration probably should not be viewed as the way in which a regulation that you that is already effective and that you are not happy with, that you wouldn't necessarily expect that the Trump administration's coming into office would result in a quick or easy change to that. The Trump administration has pledged to try to rescind regulations. You've probably read things where there's things like, for every one new regulation issued, they will try to rescind 10. But like Marty said, rescission of regulations is not necessarily that easy. If a regulation came through notice and comment, then rescission requires going through notice and comment, which is a long process and can then itself be subject to court challenges under the APA. I do think that we may see a slower set of rulemakings under the Trump administration. But I think another part of this new era to think about is not only the regulatory landscape, but also sub-regulatory guidance. So again, by this, we're talking about things like agency manuals, FAQs, guidance documents. And under the first Trump administration, there was a lot of focus placed on what the administration viewed as good governance around sub-regulatory guidance, guidance that doesn't have the rule of law, doesn't have the force of law. But the concern was that agencies were sometimes using sub-regulatory guidance, like manuals, as creating the binding rule. So, for example, in an enforcement action, even if the regulation didn't itself contain a particular requirement, an agency pointing instead to a state operations manual or to a guidance document to base the enforcement action. And under the last Trump administration, there was a lot of executive orders and guidance put out. We've cited one here to indicate that agencies should not be able to use subregulatory guidance to impose substantive rules, and requiring agencies to catalog and make available all in one place all the subregulatory guidance that existed. The Biden administration promptly rescinded those executive orders, but I would expect that we will see in the coming weeks and months more executive orders or guidance coming out of agencies that are creating sort of rules that bind themselves and their own use of guidance documents. The takeaway, I think, for everybody who is a regulated party is that this creates potential opportunity to be able to view the risk around a particular position to be different than it was before, knowing that the agencies aren't going to view the sub-regulatory guidance as binding in the same way that they may have before. This quote here, profound implications, comes out of Fitch rating, addressing the Loper Bright decision and what its effect would mean on agencies. And I think we put this here under the Trump section because I think it's all the more the case under the Trump administration. That as you think about arguments to make to the administration under, say, comments in a proposed regulation, if you're engaging with agency officials, as you're even writing your memos to file about how to view a regulation, after Loper Bright, there are new sets of arguments that the current Trump administration agency officials, I think, are going to be much more sensitive to. So looking, like we started off talking about Loper Bright, that CMS's authority comes generally out of the Social Security Act, that a good practice would be for any particular regulation or guidance to go back to the organic statute, go to the Social Security Act, look at what that authorizing statute was, and see whether it seems justified in light of the regulation put out. If it's a proposed regulation, to submit comments that make these statutory arguments. And I think we're going to find agencies much more receptive under the current administration to trying to hew more closely to the statute because they're going to be sensitive to these sort of arguments. That might mean that you have agencies less willing to be as adventurous in putting out new regulations. Now, of course, the whole healthcare industry is not monolithic, and different entities have different interests. And so one regulation may be viewed as favorable to one group. Perhaps it's a for-profit group versus a nonprofit group, or rural versus urban. And so as comments are being put forward, or as regulations are as you're considering challenging those, I think that creates another level of uncertainty as different organizations may put forward different interests. Partly for the sake of time, I'm going to keep going to what it might mean here under the Trump administration when you're thinking about legal action against CMS. I don't think that there is again, we're not suggesting that you should sort of sit back if you have a problematic regulation because of the new administration, but instead there are perhaps more opportunities than ever given Loper Bright. Considerations as you're thinking about that are being sure that you have the right counsel, the right witnesses if you're going to be seeking a preliminary injunction. Many of these suits are done under trade associations, and so considering your relationships with trade associations, and again, to consider the right forum to be seeking these. I want to flag that, particularly when CMS is involved, there are very strict rules around exhaustion, and to be thoughtful about how you would form these sorts of challenges. We are now to poll 2.
Okay, and with that, I'll read that out for you guys. What factor would be the most important to your organization in considering whether to challenge a regulation that you considered invalid? 1, the likelihood of success. In other words, is it worth it? Number 2, concern about harming the relationship with the regulators. Number 3, concern about reputational harm with patients, staff, community stakeholders. Or number 4, resources, in other words, legal fees, staff burdens, etc. And we'll give you guys a few minutes to respond. Again, please remember that to be awarded CPE credits, you must be logged in for the entire duration of the session, and you must answer the 3 polling questions. If you're seeking CLE or CHC, we really just would love to hear from you. And we'll give you guys a few minutes to respond, and then we'll let Matt and Marty comment on how you guys are responding. I don't think there is any right answer in this one. I know how I would answer.
How would you answer it, Jana?
I would answer concern with harming the relationship with the regulators, but that's, yeah, because I think that is a piece of the puzzle that you need to consider.
Yeah, I would have thought that would have generated more votes too. We're seeing that second one come in at about 10, 11%. I sort of thought that would have been more number one, front of mind, but more folks are answering first the likelihood of success. Mm-hmm. And that's where I think Loper Bright is a big deal, because the chances of success of challenging any regulation have now increased significantly.
Yeah.
So it's worth asking that question, pulling out your actual statute book and comparing it to the regulation to see how well these things map on. Resources is probably the second highest answer there. And that's, if you look at these challenges and how they're brought, they are very rarely brought by a single healthcare entity or company on their own. They are almost always coalitions, often through trade associations, in order to spread the legal fees and the costs of a challenge, which makes sense because if you're challenging a regulation, you probably are going to, if you're successful, you're going to change the dynamic for all regulated entities. So I think those first 2 factors that people that voted the highest on are things that in the particular case can be overcome.
Yeah, in so many of these cases, I mean, there's also just a pot of gold at the end of the rainbow, because you think about the 340B litigation, you think about the wage index litigation. I mean, the folks that have pursued that litigation because they result in changes to reimbursement policy, it has a significant bottom line impact. And so I think that also impacts that calculus as you're deciding whether to move forward with this litigation.
That's really well said, Marty. 2 other points about the current administration before we move on to ending with just more practical takeaways. First is administrative enforcement. So I'm talking about when HHS OIG might be approaching you on CMPs, or even survey enforcement that's often done by state survey agencies. When you have non-criminal agency enforcement, there was a lot of attention under the prior Trump administration towards good governance around agency enforcement, and I think we're going to see more of that. And what do I mean by good governance? I mean things like the following: that concerns around fair notice and due process during an enforcement action. So I've put up here a particular memo that was put out by OMB back in August of 2020. It didn't get a lot of attention. We were in the height of the pandemic, but it's very interesting because it articulates a number of, essentially, it's almost like a Bill of Rights for administrative enforcement. For example, saying that the agency must disclose any evidence that would be favorable to the regulated party during the enforcement process, or requiring that whatever the standard being enforced must have been clearly articulated in advance in some regulation that actually has the force of law, rather than a more nebulous standard or something that was only in subregulatory guidance. I think this is very important if you find your company on as the target of an enforcement action, to be looking at these sort of process arguments. And if you're not getting traction with the frontline person bringing these actions, to consider ways to appeal within the agency and really appeal to fair process, because I think under the Trump administration, there's going to be more sympathy for these sorts of process arguments. Many of you in the healthcare industry who are submitting claims to federal payers like Medicare, Medicaid, and TRICARE are also have potential risk of False Claims Act enforcement. And so it'll be very interesting to see under the current administration whether there are changes to False Claims Act enforcement. One question is the constitutionality of whistleblower suits under qui tam provisions. I'm counsel in a case where we brought a challenge to those and actually persuaded a district court to find that qui tam suits are unconstitutional because they're being brought by private individuals who are not appointed by the president. That case is going up to the 11th Circuit, and if it were to be affirmed, it would certainly go to the Supreme Court and would be a major change to private individuals being able to litigate under the False Claims Act. But even apart from that, DOJ's defense of the statute to date has been to say that it exercises close supervision over private individuals doing qui tam litigation. And so I think under the new administration, there's going to be more sensitivity to DOJ needing to actually play a more active role in monitoring qui tam litigation. And so there may be more opportunities to press DOJ to dismiss qui tam suits that don't have merits. And that likewise, I think at least the political leadership of DOJ now will be more sympathetic to arguments of False Claims Act cases being based on regulations or subregulatory guidance that isn't clear or isn't really founded in the statute and shouldn't be the basis of a False Claims Act suit. So the takeaway for this is if you have a False Claims Act problem, to look anew at some of these very fundamental questions around this False Claims Act statute, as well as the basis of enforcement. With that, I'm going to turn it back over to Marty. Actually, before I do that,
polling question. I thought so.
Yeah, go ahead.
There you are, Angie. Yes.
I am here. Polling question number 3. How often does your organization conduct compliance risk assessments? Annually, every other year, every 2 to 3 years, or never? This is the third polling question in this session today. Remember, if you are working towards CPE credit, you must answer all 3 polling questions and stay online for the duration of the session. CHC and CLE, you need to stay online for the duration of the session, but you do not have to answer the polling question. However, we would love to hear from you as you take part in our poll today. So I think we've got, I'm going to give folks a few more seconds to respond. I'm going to give our presenters some jazz hands because we were talking about that before, that jazz hands needed to be part of every presentation. So as the remaining responses come in, I think we need a few more, but I am going to turn it over to Matt and Marty to maybe comment on the poll responses.
Well, so probably going, why are they asking about compliance risk assessments in the middle of a presentation on agency regulation? I think as we consider the kind of long-term practical impacts of Loper Bright and the Trump administration, I think it really goes to how we evaluate risk. The value of the False Claims Act to the Medicare program is its deterrent effect, because as we contemplate launching a new program or entering into a financial relationship, we are always doing the risk analysis, because we well know that the statutes, the regulations, even the subregulatory guidance is rarely written to your specific fact and circumstances. And so there's always space between the rules and the proposed conduct. And we go through the process of trying to figure out how we're going to evaluate risk, and some are conservative in their approach, some are more forgiving in their approach. And I think this change in agency approach really has an impact on our internal risk management activities. As we evaluate courses of action, and many times the question has been, is there any way that the agency could interpret its rules or its guidance in a manner that would place this particular proposed course of conduct at risk? And if it's a 10% chance, it's a 15% chance, we've always sort of kind of put the finger on the scale against moving forward, because again, that deterrent effect of the FCA. But as we sort of see this realignment of the role of agencies and their relationship to the regulated, do we have to go to that extreme? Or do we give more room to, yes, there's an argument, if you stand on your head, it may make sense, that would bring into question a particular proposed conduct. But does it really deserve that weight to the extent that it is preventing us from moving forward with certain action? Do we give ourselves more leeway as the regulated to move forward? Again, less concerned about FCA liability, but also less concerned about how the agency would attack a particular issue. You know, you made reference, Matt, to the Kaiser doctrine, which says, you know, agency, we defer to the agency on their own regulation. Will we see that stand over time? Because this logic of it's the courts, not the agencies, that interpret laws. Will we extend that to it's the courts, not the agencies, that interpret regulations? So this is certainly a much more long-term effect, one we'll be watching carefully as we work as advisors to the healthcare industry.
Thank you for listening to this PYA webinar recast. The video recording, slides, and associated material for this and all PYA webinars are available on our website. If you have any questions or if we can help, please contact us at pyapc.com. Thank you again for joining us, and have a great rest of your day.